In this session, we're going to talk about agency law. Agency is a very essential part of business. You have, as we'll learn in a later week, different types of entities that are recognized in law. Um, a corporation or an LLC or an S corp, they are their own living entity. They're a recognized entity that has legal status. That is an entity and not a person. So without the agency relationships that we're going to talk about, corporations, LLCs, S corps can't function and carry out their business or their operations. A corporation can't sign a contract. A corporation can't make a decision of when to hire someone. A corporation can't decide to do things. Um, they have to carry that out through persons that have authority to act on behalf of the corporation, the LLC, the S corp. And this is where the agency relationship comes into play. Without an agent, corporations could not function or operate. So the agency relationship is comprised of two people. You have the principal and the agent. The agent is the one who's vested with the authority or the power to act on behalf of the principal. The principal in the scenario that we've been talking about would be the corporation. The agent would be the employee who acts on behalf of the corporation. So that the agency relationship, we talk about an agent and we talk about the principal. There are two types of agency relationships that we're going to talk about here. You have the employer-employee. The employer would be the principal. The employee would be the agent in that example. Sometimes you may see it in the book or elsewhere where they refer to this as the master-servant relationship. That's the old common law term for it. They didn't say employer employee, they referred to it as the master as the employer and the servant as the employee. The second type of agency relationship that you may have would be the principal independent contractor. Um, so, what's the distinction between these two relationships? What's the difference between an employee and an independent contractor? Well, there are a number of differences, and here we're going to talk about just a few of them. From the standpoint of legal liability, there's a legal doctrine known as respondeat superior. That is a term for basically vicarious liability, meaning that the employer under the law is liable for the wrongful conduct or acts of their employees when the employee is acting within the scope of their employment. So just because an employer employs an employee, if an employee on the weekend not working has a car accident, the employer is not automatically liable. Um, but if the employee was driving and was working for the employer at the time of the car wreck, then under this doctrine of respondeat superior, the employer may be liable for the wrongful act of the employee in that accident. But when you compare the employee to the independent contractor, under respondeat superior, that only applies to employees. So an employer would only be liable for the wrongful acts of employees in the scope of their employment. In contrast, the employer, i.e. the principal, who's contracted with somebody to do some work, would not be liable for the wrongful conduct or wrongful acts of that independent contractor. The independent contractor, as it denotes, there's some form of independence. And so that independence is enough that there's no vicarious liability to the principal. Um, Another area is taxes. For employees, employers are required to withhold certain taxes. If you get your paycheck, you look at it as an employee. They hold out taxes for income, unemployment, and Social Security. Employers are obligated to do that. Principals do not have that obligation to make any withholdings from an independent contractor. Instead, the independent contractor is the one who's obligated to withhold and pay those taxes. So both of these relationships are treated differently for taxes and legal liabilities. Also, it's very common that the benefits are different. Employees usually participate in fringe benefits, including paid time off, retirement benefits, insurance, could even be things like paying for gym memberships and other perks that are available to employees. Independent contractors do not participate in those fringe benefits. Usually, they just get paid whatever agreed amount for the work that they've been hired to perform, and that's it. They don't get any insurance, they don't get any retirement, they don't get any paid time off. They just get paid whatever is agreed to. Further, there is a difference between wages. Under the Fair Labor Standards Act, which we'll talk about in a later week, it's a federal law that requires employers to pay employees at least minimum wage and pay them for overtime wages. There are exceptions to the overtime wages for people. They're referred to as an exempt class. And so if you meet an exemption and are not required to be paid overtime, then you wouldn't be paid overtime. But for employees who are not exempt, and there's a large class of people that are non-exempt employees, they're entitled to be paid overtime wages, and that's defined as any hour worked in a week that's beyond 40 hours. So if you work 42 hours, they would be entitled to 2 hours of overtime pay. And overtime pay has to be at least 1.5 times the regular rate of pay. So if they're paid $10 an hour, 1.5 times $10 would be $15. So for those 2 hours, that employee would be paid $15 an hour. Non-exempt employees are entitled to overtime wages. Independent contractors are not entitled to overtime wages. Like I mentioned a moment ago, under the benefits, they're just paid whatever they're agreed upon as their payment for the services that they're performing. They would not be entitled to overtime wages. Employees would be entitled to overtime wages. Lastly, another difference between these two relationships is that employees who sustain an on-the-job injury would be entitled to workers' compensation benefits. An independent contractor would not be entitled to workers' compensation benefits. Workers' compensation laws, at least it's controlled by state, it's not a federal statutory scheme, but here in Tennessee, workers' compensation law provides that employees who sustain an on-the-job injury are entitled to receive compensation for their impairment, for their injury. And so there's a set form of calculation that takes place in which you determine and place a value on the permanent impairment or the temporary disability that the employee sustained. But it applies to employees. If you're an independent contractor, you would not be entitled, more than likely, you would not be entitled to receive workers' compensation benefits. So as you can see, there's a big difference between how employees are treated and how independent contractors are treated. So let's take an example here. You have Brandon who owns a local sporting goods store. Brandon and another person, Mark, they are the ones who work at the store each day. They're the ones who greet the customers that come in, that help them find the baseball bat they need, the right pair of cleats, whatever, and they're the ones who run it. But one morning, Mark and Brandon arrive at the store and they find a water leak. Brandon calls a plumber named Will. Will comes later that day and is at Brandon's store for 4 hours, and during that time, Will repairs the water leak. So compare and contrast Mark and Will. Mark would be an employee. He's at the store every day that it's open. He works at the owner's direction. He's an employee. In contrast, Will is an independent contractor. Will is coming that one day. He's not regularly at Brandon's store. He doesn't follow Brandon's directions. Brandon doesn't tell him how to fix the water leak. Brandon just lets him in and agrees to pay him for repairing the water leak. It's a simple illustration, but it lets you see who's an employee and who would be considered an independent contractor when you're looking at the relationships involved in this hypothetical. So it becomes a question of how do you distinguish between when a person is an employee and when they're an independent contractor? Well, there's no bright line test. There are often, as we'll see in a slide in just a minute, a number of factors that courts would consider to determine whether a person is an employee or if they're an independent contractor. So it's a facts and circumstances determination that's made on a case-by-case basis. Again, there's no bright line rule. You have to look at the facts that make up the case before you and analyze those facts to determine if a person is an employee or if they're an independent contractor. It's also important to note that how the parties define their relationship or how they refer to it is not dispositive. It may have some meaning, but they're going to, again, look at what are the facts and circumstances um, surrounding this relationship. Just because the employee and the employer say, or the the people, the workers and the employer say it's an employee-employer relationship, isn't going to be determinative. There are a lot of times that people are misclassified. As you could see from all the benefits and the lack of overtime pay and not having to provide workers' compensation, not having to withhold taxes, you could see how it would be very incentive oriented for the employer to classify somebody as an independent contractor rather than an employee. They would avoid legal liability. They wouldn't have to withhold taxes. They don't have to provide benefits. They don't have to provide workers' compensation coverage, and they wouldn't have to pay overtime. All those things weigh in favor of an employer characterizing as a worker as an independent contractor. Just because they define the relationship as one way doesn't mean that's truly what's happening. So courts look through the title that the worker and an employer place on the relationship and instead consider the following factors. So here are the factors that they look at. And there could be others at times that are considered, but these are the main factors. Control. When we say control, we're talking about who controls the details of the work. An independent contractor would be expected to have more independence in determining their work. So look back at Will and Mark. Will, as the plumber, has a lot more freedom in determining how he does his work, how he goes about repairing the pipe. Mark, on the other hand, works at Brandon's direction as an employee in the store. So who has control of the details of the work? Is there someone that's directing this, or is there really an element of independence for the worker? Next, you look at the type of work. In the example that we were just talking about, there's a big difference between the work that Will did for Brandon and what Mark did for Brandon. Mark worked in the store selling goods, helping people check out. Will did not work in the employer's business. He was there to perform the repair of the water leak. So is the type of work similar? Or is there a difference between it? If there's a difference between it, it's more likely that it will be considered to be an independent contractor relationship than an employer-employee. Supervision is another big factor that you can consider. Is the work that's performed usually one that would be supervised by the employer, or is it one done independently? Again, going back to the example we just talked about, Will's work is something that would not be usually performed under the supervision of Brandon. Will has that autonomy, that independence as the plumber to work and repair the water leak. Brandon, on the other hand, doesn't have anything to do with the water leak. He runs a sporting goods store. Mark works at the sporting goods store, so Mark is performing work that would generally be under Brandon's supervision. Skill. What degree of skill is involved? The higher degree of skill involved, the more likely that it is an independent contractor relationship. The more skill that they have and they exercise, the more that it tends to indicate that there is some degree of autonomy there as opposed to working for the employer. Another one is who provides the tools and equipment. If Will brings his own equipment, it's much more likely that he really is an independent contractor because he's providing his own stuff. He's not, Brandon's not providing him the tools. He's not providing him the equipment for the work. Mark, on the other hand, any goods that are sold, any elements that he has to use, like a computer to look something up to order or a register to check somebody out, that's all stuff of Brandon's. That's not something of Mark's. So who brings the tools can be an indication as to whether there's an element of autonomy and independence which usually is associated with an independent contractor relationship. Next, you look at the duration of the work. If it really is an independent contractor type relationship, they're normally not somebody who's going to be working there all the time. Now, they may be working there for an extended period of time on a job, but they're not a normal, regular, everyday employee. So if you look at the example we've talked about, Mark, he's there for the duration. He would presumably be an employee at will who is there working until he either is terminated by Brandon or he decides to leave and take a job somewhere else or retire. Therefore, Mark, the duration of his employment is indefinite until that relationship ends. Will, on the other hand, is only there for a short period of time, and he's there contracted to do the simple repair of the water leak and be done. You also look at the form of payment, the method of payment. If you're paid by, time based on like hours, or paid a weekly amount, that's more indicative of a employer-employee relationship. But if you're paying them by the job, like Brandon would be paying Will by the job to perform the repair of the water leak, he's paying him for that job. He's not paying him by the hour every week. So the form of and method of payment can help shed light onto whether it's really an employer-employee relationship or an independent contractor relationship. And lastly, you got to analyze, and this makes a lot of sense, is the person, the worker, performing services for anyone else? If they're performing services only for one person or one entity, it's much more indicative of an employer-employee relationship. There's a lot more indicative of an independent contractor relationship if the worker is performing services for multiple people or entities. So going back to the example that we just looked at, compare and contrast Mark. Mark is performing services for one person, Brandon, in his sporting goods store. On the contrary, Will is performing repair work for multiple people, multiple entities, and so his relationship is much more indicative of an independent contractor because he performs services for other people. So, like we were alluding to a moment ago, based on the differences that we talked about between the employees and independent contractors, employees are often tempted to try to classify workers as independent contractors. It allows them to avoid things like the tax withholding obligations, not have to provide the benefits that we talked about, or workers' compensation, and they may be able to avoid overtime wages. For that reason, the relationship of an independent contractor is much more favorable to the employer. Employers, however, they have to be careful that they accurately and appropriately classify workers. The Department of Labor and the IRS can have the authority to come in and audit employers and to we talked about looking at these factors and looking at the facts and circumstances of the actual relationship, and they will do that and may determine that they have improperly classified the relationship. They may have said, these people work for us, but they're really independent contractors. The IRS, the Department of Labor, may say, no, we disagree with that. You say they're independent contractors, but based on the facts and circumstances, considering the factors that we just talked about, we conclude that these workers are really employees. The book talked about this in the example of Microsoft in the 1980s. There were a number of people that Microsoft employed. Microsoft said they were independent contractors. You go back to some of the stuff that we were talking about, they were only performing work for Microsoft. They were working there for a long time. Things that were indicative of an employer-employee relationship, not the independent contractor relationship. And misclassification of workers has been a very hot button issue for the Department of Labor over the last few years. They released some guidance really hammering home this autonomy and independence that they're looking for through these factors that we considered. And they believe that employers have misclassified a large number of employees or workers as independent contractors instead of employees. And so for that reason, the Department of Labor for the last few years has been focused heavily on trying to audit and determine where workers have been misclassified. So some people have looked at this and thought, well, maybe the right way to avoid these misclassification problems is we'll hire temporary workers from a staffing agency. Well, that's a good and smart move, initially at least, but it's not a solution to the problem. Um, First, you usually have a higher cost involved. Staffing agencies, um, the way it works is the staffing agency will pay workers $10 an hour to work at somewhere, but for the staffing agency to make money, they're charging you for that worker being provided there, and they may be charging you $15 an hour for that worker. And so um, you're paying a premium to use a staffing agency. Now that may be make business sense for you as an employer, but the arrangement is not necessarily the most cost effective when you compare it to avoiding some of the fringe benefits or workers' compensation, things like that. There is a higher cost associated with using temporary workers through a staffing agency. And probably most important is that there's a notion or a concept known as joint employment. Under the joint employment rule is the employer and the staffing agency are both viewed as employers of the worker. So even though the employer may think, well, he's really working for the staffing agency who's assigned him here, under the law, they'll look at it and may classify it as a joint employment relationship. And if that happens, then the employer has to treat the temporary worker as an employee, and you lose those benefits of them being perhaps considered an independent contractor. Next, let's talk about fiduciary duty. A fiduciary duty is an obligation to act in the best interest of another person or entity. So the fiduciary duty example, classic one is a trustee. A trustee of a trust has an obligation to the trust benefits to act in a fiduciary duty. Um, in that example, the trustee can't do anything that would harm the value of the trust for the beneficiaries. So he can't take the money and invest it in something that's going to lose money or is very risky. That would be against his obligation to act in the best interest of the beneficiaries. Same thing, you have a corporation, they have a board of directors. The board of directors has the fiduciary duty to act in the best interest of the shareholders. They've got to make decisions that protect and should be in the best interest of the shareholders. So there are a number of components to this fiduciary duty. The book talked about a few of them, and there are a few more that we'll talk about over the next couple of slides. A lot of these duties derive under Delaware law. Delaware is a very unique uh, state for all this corporate law. There is something, I don't remember the exact number, but it's something like 50 or 60% of all major corporations are incorporated under the laws of Delaware. Excuse me. By being incorporated under Delaware law, Delaware is very adept at the business rules, the business law components of corporations, LLCs, things of that nature. And so, for that reason, I looked at the duties, the fiduciary duties as defined under Delaware law, and we'll talk about a few of these in a moment. So, the first is a duty of loyalty. Under the duty of loyalty, which is a component of the fiduciary duty, the concept is that the agent has a duty to act for the benefit of the principal. The agent can't act on behalf of themselves or for private interest of someone else, like a sibling, a father-in-law, a spouse, a great best friend, whoever. They're prohibited from acting in the interest of someone else or themselves. And instead, as under the doctrine of a duty of loyalty, they have a duty to act in the benefit of the principal. Let's take an easy example of an employee works for a corporation. Um, as an agent of that corporation, he has a duty of loyalty to the corporation. So if he decides that he's going to open his own company, he would be violating his fiduciary duty, specifically the duty of loyalty, if that employee started trying to solicit the employer's clients away while he's still working for the employer. So if you have an employee who is going to open his own business, and he calls on clients in a sales position, if every time he starts calling on clients near the end of his employment there and starts saying, hey, by the way, I know I'm filling this order, but I'm also going to be opening my own company and we're going to be selling the same product. Here's my new card and contact information. I'd love it if you give me an opportunity to try to, beat this price and get your business. Obviously, in that scenario, that employee, as an agent of the company, is acting for his own benefit, not the benefit of the employer. He would be in violation of the duty of loyalty. So the next duty that is a component of this fiduciary duty is a duty of care. So an agent has a duty to try to avoid mistakes and errors. The agent is to try to act in a manner in which he's prudent and he is careful in making decisions. Part of that means that the agent has a duty to become well informed before he makes a decision. So you're acting with a duty of carefulness when you have gone out and you've read the material, you've asked for help, you've gotten all the information that you can to help you make a well-informed decision. Next, you have a duty of obedience. These are some of the ones that I'm saying came from Delaware law. Duty of obedience, the agent has a duty to abide by the principal's reasonable and lawful orders. So if the corporation tells you that you must sell a piece of property, even if you disagree with it, as the agent, you have a duty to abide by the order of the corporation to sell the piece of property. Duty of confidentiality, the agent has a duty to keep information confidential if it's required. That kind of speaks for itself. Duty of disclosure, an agent has a duty to act with complete candor and thus must disclose all facts and circumstances that would be relevant to a decision. So if the employee, the agent, knows information and doesn't disclose it, he could be in violation of his fiduciary duty because he's supposed to act in the best interest of the employer. And in that scenario, if he's not acting with complete truthfulness and candor, he may be violating his fiduciary duty. Last is there's a duty of good faith. So the agent has a duty to perform his or her duties in such a manner that is reasonable and does not violate the law. So let's talk about the agent's authority now. An agent has the authority to bind, is the legal term that's used, the principal through either actual or apparent authority. By saying they have the authority to bind the principal, we're meaning they have the authority to commit the principal to doing something. The easy example is they have the authority to bind the principal to a contract. So if they execute a contract saying that we'll buy, widgets or we'll buy property, they have the binding means that they've committed the employer to buying that material or buying the property. So actual or apparent authority is the terms that are critical here. So an agent has to act with either actual or apparent authority. If they lack that authority, then the activity is considered outside the course of their scope and should not be binding. Maybe scope's not the right word. Outside their authority, and therefore would be an act that's not binding on the principal. So what is actual authority? Actual authority is where the principal intentionally and purposefully tells you, agent, you have the authority to act on my behalf to do X, Y, and Z. An example is in a board meeting. The corporation gives the CEO the authority to execute contracts to purchase another company. They say, CEO, we authorize you to memorialize and facilitate and execute the purchase of a corporation. So actual authority is usually documented in some form or fashion. Most often in the setting of a entity, it would be in either the board minutes or in some operating agreement or bylaw. Usually the authority is memorialized somewhere. And it's important that that authority is memorialized in some record, and that authority or that record is kept so that if there's ever a question about the scope of somebody's authority, you have that record that helps show it. So you'll hear them referred to as actual authority can either be expressed or it may be implied. So express actual authority, that's exactly what you would think it is. It's where the principal gives unequivocal authority by either words or action. An example of words is the CEO directly tells the HR manager to complete the employment contract for the new operations supervisor. In that instance, it's clear, it's unequivocal that the HR manager has been given the authority to act as an agent on behalf of the company to execute an employment contract. So by action, an example would be where the CEO just sends the HR manager the signed offer sheet. If you send the signed offer sheet to the manager, and the manager is obviously expected to then complete that hiring, and that would include putting together an employment contract and having it executed. So by there, you're telling them you've got authority to complete this hiring. So express authority can also be found when the agent has a, quote, justifiable belief, close quote, that the principal gave the authority. So in the example above, on the action, if the CEO sends the HR manager the signed offer sheet, the HR manager has a justifiable belief that the CEO wanted the HR manager to hire that new operations supervisor. Through that, the HR manager would be reasonable in his reliance upon having actual authority to hire the person. So if there was a question about it, there would be a justifiable belief and it would be binding on the corporation. Implied actual authority. This is what you would expect it to mean. It's where the agent may also have implied authority to act as is reasonably necessary to complete a task. So you can derive this by either looking at usual authority, in other words, the authority that would typically be given based on past instances. So every year something happens, and every year you've been given the authority to complete some, the example here is the CEO instructs the operations VP to plan the company retreat. The operations VP has implied authority to execute the contracts to rent meeting space and hire a catering company. That could be implied based on that's what we've usually done in the past, and that in the past he's always been told you need to, rent the meeting space and hire a catering company, and you've got authority to do it. So if they've had that authority in the past, then that would be applicable here. You could also have implied authority based on custom. So that's the authority that the agent would usually have. If you looked at outside the industry, it'd be customary for the employee to have that authority. So in this example of the VP planning the company retreat, it's implied that he has the actual authority to execute contracts to rent meeting space and hire a catering company, because in order to plan the retreat, that's part of what he would have to do. You'd have to have a place to meet, and you'd have to have food to eat. Apparent authority exists when the third party is led to reasonably believe that the agent has the authority to act for on behalf of the principal and has the authority to bind the principal. So this is where you haven't expressly been given authority, but the third party is led to believe that the agent has actual authority. So it can exist based on the words or acts of the principal or based on past history. So if the agent has in the past had authority to act, then it's reasonable to believe that the agent continues to have authority to act on behalf of the principal. The principal can make comments or take steps to lead a third party to believe that the agent is the one who has authority to act on their behalf. It's important to note that it's the principal and not the agent that creates apparent authority. So if the agent is the one who's saying, I've got authority to do X, Y, and Z, that can't create apparent authority. It's got to be words or conduct by the principal that establishes apparent authority. So the example we have here is the CEO tells a third-party vendor that the VP makes all purchasing decisions. Well, that's words by the principal, the CEO acting for the principal, that the VP has apparent authority, that they have authority on making purchasing decisions. So the third-party vendor reasonably believes that the vice president has authority to execute a purchase agreement, when in fact he may not. But in this scenario, because of what the CEO has told the third-party vendor, the vendor is led to reasonably believe that the agent has authority to act on behalf of the principal and execute the contract. If you have where the agent performs an unauthorized act, if the agent really, in the last example we just did on apparent authority, if the agent really didn't have the authority, that is that VP, to execute the purchase contract with a third-party vendor, that can be cured through ratification. So the principal has the authority to ratify the act, and it cures the lack of any authority. Once that purchase agreement is ratified by the company, then the act is as if the agent had the authority all the time to bind them. So it cures the lack of authority. Undisclosed principal, this is another concept that comes up in these dealings. It is lawful for the principal to remain confidential, private, unknown. So if an agent is acting on behalf of a principal to a third party, and the third party may know that they're acting as an agent, and they may want to know the identity of the principal, they have no legal right to know who the principal is. Under the law, the principal can remain unnamed, unidentified. So there are times when it's strategic for the principal to remain unknown. So if it's a valuable company or a highly wealthy person, then it's strategic for them to perhaps remain anonymous, because if the third party knew who the principal was, they may try to seek a premium out of that person and seek a higher amount of money to buy a piece of land or to perform some service. So it makes sense that there are times when an undisclosed principal has its benefits. In this scenario, if the agent acts outside of their authority, the principal should not be bound by that act. So if the agent exceeds any scope of their authority that's been given to them, whether it's express or implied actual authority, if they operate outside of that authority, the principal, their undisclosed person, would not be bound. However, the third party may have a claim against the agent. So the agent could be held personally liable in that undisclosed principal scenario. Respondeat superior, this is just a little more on that doctrine. We talked about it when we talked about the differences between the employment relationship and the independent contractor relationship. So the employer of an agent will be liable for personal injuries or property damages that's caused by the agent while the agent's acting in the course and scope of their employment. Like I said earlier, this doctrine is also referred to as vicarious liability, and this doctrine is limited to employees, not independent contractors. So the key to liability is that the agent employee must be acting in the course and scope of employment. That makes sense. You go back to the example we used of the employee who's driving a car on the weekend versus an employee who's driving uh, his car during working hours and driving it for a purpose of the employer. So if it's a person that is a salesman, if he has an accident while he's driving from the office to an appointment to meet with a client about purchasing some product, that accident would be one that would be within the course and scope of his accident. And if the employee was negligent in causing the motor vehicle accident, the employer may be liable to the third party that suffered harm in the accident. But if the employee was driving on the weekend and he was driving from his home to his son's baseball game, he's obviously not working at the time of the accident, and his employer would have no liability in that example. So here you've got some factors that's applied a lot of times to help, because sometimes there can be a gray area as to whether the employee is acting in the course and scope of their employment. So let's go back to the example of the employer employs the employee. He is a salesman. He's leaving his office, driving to an appointment with a client, but he decides that he's going to quickly swing by the bank and get some money out so that he can take his wife out for dinner later that night. Is that really something he's doing for work, or is that really something now that he's doing on his own personal time? And assume that as he's traveling to the bank, he has an accident. Well, who's liable then? Is the employee acting in the course and scope of his employment, even since he's technically en route to a client, or is he outside the course and scope of his employment and now he's pursuing a personal uh, endeavor? So some of these factors that you would look at is whether the employee's act is authorized by the employer. In that instance, he's authorized to travel from work to the client's office, but the employer really hasn't authorized the employee to drive from work to the bank to then the client. Um, Next, you consider what's the extent of the employer's interest. Are they being advanced by this act? Going to the bank to get money out to take his wife to dinner, while a good and noble thing, is not advancing the interest of his employer. Next, you look at whether the employer furnished the instrumentality that caused the injury. It's a possibility that in this example that the employee is driving a employer provided car. So that one would, uh, if there was an employer provided car, that would support that it had an element of being in the course and scope of his employment. However, that's not alone dispositive. And then lastly, you look at whether the employer had a reason to believe that the employee or know that the employee would be performing this act. In this instance, the employee may have told the employer that I'm going to go by the bank and then I'm going to go to the client meeting. They may not have, it's not specified. So that reason could go either way. And so in this scenario, it's kind of a gray area of is that little detour to go to the bank enough to remove him from the course and scope of his employment? In my opinion, in that scenario, I believe it's most likely that a court would find that the employee was still within the scope of his employment because he was only taking a momentary short detour for personal reason, but the overall reason for his trip was to go on a visit to the client. So that conclusion brings us to the detour versus frolic concept. So the detour is considered a minor deviation from the employer's business, and it would still most likely be considered within the scope of employment. The deviation to the bank is a short, small, out of the way deviation. Now, if he deviated and went to the movies and watched a movie for 2 hours, and then after leaving the movies, coming back to go to the client visit, had an accident, That's much more of a frolic, which is a substantial deviation from the employer's business and is outside the scope of employment. So in the example that we just gave, I think it's more akin to a detour than a frolic. So it's still possible in some scenarios that if the employee is considered to be acting outside the scope of his employment or her employment, that the employer could still be liable. Here are some of the reasons. So the employer intended the employee's conduct or consequences. The employee's position makes him or her the company's alter ego. The employee's actions attributable to the employer's own negligence or recklessness. The conduct violated a non-delegable duty of the employer, meaning that it wasn't something that the employer could trust to the employee. Or the employee purported to act on behalf of the employer and there was reliance on apparent authority. These are all the very facts and circumstances based determination to know when you could impose liability on the employer even when the employee is acting outside of the scope of their employment.